this is remedies. We're going to start section 12 today. Before we do, I want to make a few more comments about section 11 with respect to valuation of damages and making demands and trying to establish a reasonable value for your claim that is supportable both prior to filing suit and then during suit. But I also want to address, a few people have asked me, what do your exams look like? What should we expect on the final? So I think I'm going to spend a few minutes telling you a couple things about that. You need to look at my old exams. They're on reserve down at the library desk. They're also online. The remedies exams look a lot like the civil procedure ones because, as I see remedies, it's an extension of civil procedure. But you could focus on the remedies ones. What you're likely to see in the same format for a number of years now is there'll be 10 relatively short terms that need to be fully explained by you, well defined and explained by you, and then take those terms and see if they apply, if at all, to the fact pattern that you have that would be contained in the second portion of the test, which is the essay exam. I think when you're learning the law, you're learning a foreign language, so that you need to know basic concepts within that field of law really, really well. And so that if you don't have a good handle on the concepts that as you go through the course of the 15 weeks, then you need to go back and really start to think about what they might be. I would think that if you made a list of 25 or 35 concepts, you would be able to clearly cover the 10 that are likely to be present on the exam in that section. And then the second part of the test, and the more important part of the test, but they each obviously affect your grade, is the essay. The essay is a relatively standard essay question that you might find on the bar exam. And what it's obviously going to deal with is someone or some entities that have a legal problem that they expect you to address, oftentimes with some dispatch. And I would expect that you would address it from the standpoint of soup to nuts. And by that, what I mean is that to really assess the strength of the claim at the outset, talk about what your choices are as to where you would be looking to try and resolve that situation, what courts, why, what courts you're likely to be able to bring all the various parties before, what type of relief you might be seeking, obviously including equitable relief as potential and as well as potentially money damages, who the proper parties are, and then talking about how that you would expect the court to deal with the various issues that are contained in that fact pattern and in that case. I would expect that much of what we have discussed over the course of the semester is likely to find its way into the essay. Obviously, everything won't find its way there, and they may be reasons why some of the shorter questions are there as well. But what I'm looking for is a mastery of the material, ability to define the concepts well, to apply them when you see them, and then at some point conclude and move on. There's a page limitation. I think it's 6 pages on the essay. The other portion of the test goes right into the test. You shouldn't be pressed for time. I would tend to think that it's in a 3-hour exam. Most of you will finish in between 2.5 and 2 hours and 45 minutes. But I always tell folks that I think it's really, really important to slow the whole process down, to think about what you want to say, to outline your answer, and then to start out when you express it so that you're expressing and putting your best foot forward as to what you think the solution is. It always seems wasteful to me and really not a good idea when I get to an essay and the 3rd page in someone says something along the lines of, well, forget what I just said, I want to start here. Well, I'm not going to forget it, I already read it, and it seems like you would have been better off starting all over again if you really think that half your essay is misdirected at this point. And so that's why I think it's important to think about what you want to say and express it, and to use an outline so that you capture the points, because it's not always smart to address the essay in chronological fashion, because the most important points might not be the first things that are mentioned. And, you know, when a client sees us, what they expect us to do is sort of marshal a plan as to how to go forward, and then direct our energies at that. And I think that's a good way to think about what your essay should look like as well, is that, you know, draw me in from the outset that you know what you're doing, you've got a plan, and it's a solid plan, and here's what it is, and here's why it is. You know, the fact is that the solution isn't always as important as how you're getting there, and the recognition that there are obviously likely counter-arguments to be made about whatever you're doing, some more important than others. And if there are more important ones that you expect to be raised, you should be talking about those as well. But I don't think you're going to find a lot of surprises if you look at my old exams. The fact is we've got changing technology, but a lot of equitable law is not even just centuries old, but thousands of years old. So the fact is we're applying a lot of old law to new situations. And so I would think about what's likely to be there. But I also, if you're worried about what's likely to be there, then maybe take one of the old exams and use it as a practice exam. Take it under exam conditions, and then see what you've got, see what you like, and see if you think that you could improve upon it. Obviously you could, so that when it does come time to sit down and take that exam on a 3-hour basis, that you really won't be surprised. Because I think it's pretty straightforward. I think the material isn't overwhelming, but there's a lot of different issues that we've talked about through the course of the semester that I think they're likely to find their way into various portions of the essay or the short answers as well. And so what you want to be able to do is address those issues, so that when I read your essay, I get that you get it. I get that you understand it, that you can explain it well, and that in essence you've mastered the material that's we've been talking about for a period of time now. Questions on the exam? Everybody, whether you're online or in person, take the same exam. I forget what day it is, but I know it's 6 o'clock at night. It's a 3-hour exam. I wouldn't expect that you would feel pressed for time. I don't like a time-sensitive exam myself. I'd rather give you some time to think about it and be able to express your thoughts reasonably well than for you to feel the press of time. Although obviously, depending on how much time you organize and think about it, you still have a time limit of 3 hours total. But I don't think it'll be a crush as some of the exams are. Questions on the final exam? Everyone knows what it looks like. Everyone knows what they should look at the old exam so that they know exactly what the format is and what it looks like. Okay? Let's talk just briefly before we get to Rule 57 and declaratory judgments. There are a couple of other things in the articles that I just wanted to mention to you as you start to think about, okay, how do we make a living at this business, and how do we, when we do have a claim, how do we justify what those damages are, and who do we justify them to? You know, the fact is almost all claims, whether they're against businesses or against individuals, or they're for personal injuries or breach of contract, start with some type of demand instrument on the other side. Obviously, if it's a 93A action, it has to start, for individuals, has to start with a demand letter. And a demand letter is simply trying to explain to the other side what it is you're seeking from them. The fact is, we don't usually go to court without telling the other side that we have been wronged in some fashion, and that we expect relief for that breach. And in the event that they don't resolve that amicably, then we do intend to file suit. But the fact is, you can't just stick a $1 million number on it or a $2 million number on whatever it is you say you've lost. You've got to justify how it is you're arriving at whatever it is you're asking for. So if it's a breach of contract between two businesses, then is it the cost of cover? Is it your other incidental damages? But that you need to explain. You can't just explain, well, this is what I want. It's $2 million to cost to cover and incidental damages. Well, how'd you get there? The fact is, if you want to begin a dialogue, and you really do need to think about the demand and the institution of litigation as the beginning of an exchange, hopefully, that would lead to a resolution of the conflict. The fact is that you need to do your homework. You need to dot your I's and cross your T's. You need to have a defensible demand figure, a defensible argument as to how you arrived at whatever the number is. You know, the fact is that in some situations, the other side will want to talk and try to discuss numbers reasonably. Obviously, everyone's looking for a deal, but the fact is, if you can support your argument for damages and liability, obviously, if there's in the event there's no liability, we're not going to get too far down the road to damages. But assuming that you've got a claim which would suggest that there is some basis for legal liability, now what you need to do is support that liability claim with a reasonable, although high, I imagine, demand for compensation. The fact is that there are situations where that dialogue then can start right away, even prior to litigation. But if you're just pulling numbers out of the air, and then when we do talk, you have no way to defend how you arrived at those numbers, or you have no explanation for them, then the fact is we're not going to have a very fruitful exchange. On the other hand, if you have got either the comparables in the real estate situation, or you've got legitimate cost to cover if you need services or if you need goods, or if you have a personal injury claim, when you can show your special and general damages and how you've arrived at them, so when one looks at them, they look like there's some basis in reality for how we've arrived at those numbers, then the fact is that there may be a fruitful discussion, or even if there's not going to be, then I'm in better shape by the time I do file suit. I think the article on 10 mistakes that justice see attorneys make explaining pain is good. I think the whole idea about how we take these really non-economic concepts and make them economic so that one can see from the standpoint of what the loss is, how it's arrived at, in fact gives us a basis for, hopefully, a resolution down the road. It also helps you crystallize your own thinking as to what this claim is likely worth, and how you may likely, if we have to file suit and go to trial, how you're likely to offer evidence on these issues. And that's an exercise that you need to do both for your own standpoint at the outset, as well as the client at some point is going to want to know what you think the range is of their potential damages. The fact is, you're asking them in all likelihood for a lot of money to advance to you. Well, I need to know what the likely return on that investment is at some point. And so this whole notion of the abstract, you know, what can I get out of this claim to what we're likely to see down the road, you need to start to think about that in harder terms. Because at the end of the day, when someone's been injured in a car accident, or you've got a commercial breach where there's a breach of contract, but the damages still lead themselves to some level of speculation. The fact is that at the end of the day, we try the case, we still have a range of numbers that we think are likely to be in the mix. But at the end of the day, so much of it lends itself to the argument that it's speculative, that we've got to try and put more support for all of these items as we think about trying the case, and hopefully succeeding so that those losses can be seen in economic terms, because at the end of the day, that's how you pay your bills too. So you have to start to think about it to a much greater extent, and especially some of these where we tend to think of them as economic losses, and they are. They're a lot harder to put a value on in a lot of these areas. Let's talk about Rule 57, which is declaratory judgments. The reason we have to study declaratory judgments is it's a classic equitable remedy. And it's covered by a rule as well. And what it allows a party to do is to petition the court by way of a complaint for a declaration as to its rights and obligations, and it has to be to a real or threatened controversy. Now, Rule 57 says that the existence of another adequate remedy does not preclude a declaratory judgment that is otherwise appropriate. And that's really, I think, a part of the key here. You oftentimes do not see a separate declaratory judgment action any longer. The fact is that if a declaratory judgment is sought on its own, then the court will at some point issue a judgment and declare what the rights and obligations of the parties are. But to the extent that that resolves the controversy, it doesn't necessarily, because it simply is a court's declaration as to what the obligations are. Parties can still breach it, and the fact is we still may have a subsequent suit. So a lot of times, if you see Rule 57 and the declaratory judgment used at all, in my opinion, these days, it's usually coupled as one of the many counts in a complaint. I've done a lot of civil litigation. I would think in all of those years, I probably saw 3, maybe 4, that had a declaratory judgment as the main thrust of the case. And I don't even think it's 4, I bet it's 3. And part of that, those actions for the most part, have been with respect to union and benefit matters, where I represented teachers for many, many years, union members, and the questions would have been oftentimes by the insurance carriers or the benefits payer as to what the rights and obligations are when there's potential multiple claimants, multiple families, children from a first marriage, partners from a second, all competing potentially for the payout. And what you've oftentimes seen, what I've seen it is in play with an interpleader action where whoever it is that has the benefits, the retirement or the insurance or the policies, looking to remove themselves from any further liability, but not being certain as to whether the policy continues to be in effect, or if it is, who among the various claimants should get it. And so what happens in those cases, and this is where I think it's used more often than not, is that as part of another action, a declaratory judgment is sought as well. And under those circumstances, the court can entertain both matters at one time and then issue the declaratory judgment determining what the rights and obligations of the parties are. Insurance carriers, not just in the benefit situation, would tend to use them more often than not, either as we saw in the Timmons case where there's some concern about whether they have to cover anything at all because they feel it might be outside the policy, or B, if they do, what their limitations are. And so a party can seek a declaratory judgment from the court asking them to determine what the rights and obligations of the parties are. The problem comes in is that it doesn't necessarily fully resolve the matter, simply because there may be further skirmishes down the road, or a party may choose to disregard what the court's declaration was, and we still have additional litigation that's going to follow. So I've never seen it as a separate action in my practice. Sometimes you get some of the more high-profile things where people are concerned about their constitutional rights and their ability to do certain things, and you might see under those circumstances a separate and independent declaratory judgment action. It just tends to be very rare. I'm going to do the cases unless you have a specific question about declaratory judgments. Stifel versus Thompson is the first one. The other part of the equation here is the Anti-Injunction Act. And the reason that we have to worry about the Anti-Injunction Act in Section 12 as well is that in these situations, when parties are worried about declaratory judgments, it's not just about the contract necessarily being needed to be interpreted by the court as to what the rights and obligations of the parties are, but it may well be, and oftentimes we see this in the constitutional aspect of it is the question about compliance with state or federal law, and when there's conflict between them, it's where we have additional issues that come into play here as well with respect to the declaratory judgment and the Anti-Injunction Act. The Stifel versus Thompson case is, in fact, a free speech case. And so we've got a couple of interesting things going on here. There's a state criminal statute that the plaintiff here is worried about being prosecuted under. And the reason, I think, in part, he's worried about it is that others have already been prosecuted by it. Prosecuted under it. He feels that he's within his First Amendment rights to continue to protest the Vietnam War by providing this information. But the problem is that he's been told that if he continues to do that, then he is going to be arrested. He doesn't want to have a criminal record. And so the first part of it is before the court ever can really entertain a declaratory judgment, because this is another problem with it. The window for seeking a declaratory judgment is relatively narrow. There has to be an actual controversy, a real or threatened controversy. But once he's been arrested and charged with the criminal violations, well then at that point the controversy is too ripe, and out of respect to the state court's ability to resolve its own controversies, you can't seek a declaratory judgment in the federal court, because the state has to honor whatever constitutional rights he has. And so if he waits until he's arrested, then the window for seeking a declaratory judgment at that point is closed. But one of the arguments to defeat any declaratory judgment action is to argue that the controversy isn't sufficiently ripe at this point, that there is no, quote, actual controversy. So let me ask you about that. Does he have, when he petitions the federal court here for a declaratory judgment, is there an actual controversy? Because he hasn't been arrested yet, right? What arguments does he have that he will be subject to prosecution under the state statute if he continues to pursue what he sees as his constitutional rights? His friend has been arrested for basically the same activity, right? Does that make it sufficiently ripe so that it's not, as it says here, imaginary or speculative? He has been twice warned to stop handbilling that he claims is constitutionally protected, and has been told by the police that if he again handbills at the shopping center and disobeys a warning to stop, he will likely be prosecuted. We have an actual controversy that we can go to the next step then? Everett, you don't think so?
Likely is not being prosecuted.
Say what?
Likely prosecuted is not the same as being prosecuted.
Warning stop, he would likely be prosecuted. Would you go back at this point?
I think he said that he intended to.
Okay, but would you? Everett says, well, he's not, likely doesn't mean he will be. You really don't think so? His buddy's been arrested. He's been warned twice to stop. If he comes back, disobeying a warning to stop, isn't he likely to be arrested? And again, once he's arrested and charged with the state criminal statute, his window for a declaratory judgment is over. So how close does he actually have to get? Likely isn't good enough? Or likely is good enough? Because that paragraph goes on to say, it is not necessary that petitioner first expose himself to actual arrest or prosecution to be entitled to challenge a statute that he claims deters the exercise of his constitutional rights. But we've got to decide whether it's sufficiently ripe. You think he's going to be arrested if he goes back again and petitions and starts handbilling?
Yes.
I do,
Yeah.
right? I don't think he's got to, I think if he goes back, that the likely will turn out to be almost definite. How many times can you allow him to violate what the police believe the state statute is in effect, and continue to warn him when he's been told if he does it one more time, he's likely to be arrested? He's got an actual controversy here. And so the question then becomes, well, if he hasn't been charged and if there is a sufficient controversy, is this a situation that the federal court could properly, potentially issue the declaratory judgment, or is this something under Younger versus Harris? And we see this in other contexts as well, is should the federal court stay out of state court matters? Certainly pending state court matters become an even bigger problem, because, as it says here, it turns on ultimately on principles of equity, comity, and federalism. Federal courts should ordinarily refrain from enjoining ongoing state court prosecutions. But in this case, at least at this point in time, he hasn't been charged with a crime in state court, and so therefore, if there is a controversy, Younger versus Harris shouldn't be a problem for it, with able to go forward. He's sort of in a catch-22, as the court notes, right? He's got no pending state court action, so he's subject to this argument that it may not be sufficiently an acute of a controversy at this point. But at the same point, without the pending state court action, he's in better shape to be able to go to federal court, because the federal court then doesn't have to enjoin any pending state court action. There is no pending state court action. And the fact is, the federal courts would be reluctant to stick their nose in pending state court matters, because they shouldn't be doing that. If he's got a constitutional right to handbill, the state has to entertain that defense as well. The Constitution, at the end of the day, governs all actions in federal and state court. And so if he's got that right, they would have to entertain it. And the fact is, he's got a problem if he intends to try and get a federal court to enjoin that pending state court prosecution. But here, as it says, when no state prosecution is pending and the only question is whether declaratory relief is appropriate, the congressional scheme that makes the federal courts the primary guardians of constitutional rights and the express congressional authorization of declaratory relief afforded, because it's less harsh and abusive remedy than the injunction, becomes factors of primary significance. And so now the question is, the federal courts are empowered to do it. Is this one that would be appropriate for the court to look at and think about declaring what his rights and obligations are to this actual or threatened controversy? Why not? Why shouldn't the federal court look at this and allow him the opportunity to have his constitutional argument heard in federal court, and in fact, if he's within his constitutional rights, then he doesn't risk exposure in state court, well, necessarily risk exposure in state court. Isn't this exactly what the declaratory relief should provide? Is the ability to provide some comfort to someone who wants to exercise their legal rights without potentially exposing themselves to even incarceration, depending on the circumstance here, if in fact he's got a constitutional right to be present and to handbill as he sees it. Would you issue the declaratory judgment?
The court said this is exactly what the Federal Declaratory Judgment Act was made for, because injunctive relief is too extreme here.
So, and they could go hand in hand, but at least one part of it would be, if we issue a declaratory judgment, then both he and the state knows what his rights are under the circumstances. There may not be a need to go any further with issuing an injunction against the state statute at that point. And if that's the case, if the Declaratory Judgment Act would resolve it, if the declaratory judgment, wouldn't resolve it, but necessarily issue clear guidelines to the parties to this actual controversy, then perhaps it would be the end of it, and there'd be no need for an injunction. You know, I thought the footnote in 19 was interesting, just from a little bit of background. It says, the fact that his buddy is being prosecuted doesn't really make any difference in this case. It doesn't affect his claim, because then it goes on to talk about Roe versus Wade. While the pending prosecution of Dr. Halford under the Texas abortion law was found to render his action for declaratory and injunctive relief impermissible, it did not prevent our granting plaintiff Roe, against whom no action was pending, a declaratory judgment that the state was unconstitutional. So Roe is the one that sought the declaratory judgment. Roe's the one that gets whatever credit for that decision, having sought the declaratory judgment. But there's another doctor in Texas at the very same time, Dr. Halford, who's being prosecuted under that statute. And obviously any right to obtain declaratory relief on his behalf at that point was too late, because the fact is he was being prosecuted under the pending state statute. Again, it shows you how that window operates with respect to it, but the fact that others are being prosecuted under the statute, frankly, allows, I think, both Roe and allows our plaintiff here to be able to show that the controversy is real and it's not just imaginary or a worry but not realistic. The fact is that it is in fact realistic, and he is likely to face prosecution. The court, and we see this in not just in speech cases, but there will be, the benefits cases, the ERISA cases, where we've got pension retirements and the like in play. The federal court is always reluctant to enjoin state court cases. And they're not going to enjoin the cases themselves necessarily, but they would enjoin the parties from proceeding with those cases. But because we've got a system that's supposed to provide mutual respect to the other courts, it still is difficult to be able to get such an order. And as Jim points out, what they have done here at the end of the day is sort of sidestep the injunction issue right now because of the concerns about how that would potentially affect the state's, the respect for the state's ability to resolve its own disputes. Nothing would stop or work against a federal declaratory judgment under this case. The plaintiff raises legitimate free speech issues with respect to his constitutional rights. There is no pending state court matter. This is almost the exact textbook case where the court should consider issuing the declaratory judgment, and in fact can do that where there is this genuine threat of enforcement of that state criminal statute. If, in fact, he is ultimately charged, the state would still have to entertain his constitutional defenses. But at this point in time, absent those pending charges, there's nothing that would prohibit the federal court from issuing a declaratory judgment, and there really is nothing that would prohibit the federal court from issuing an injunction to support that judgment at some point. But I think right now the concern is that there isn't necessarily a need for it, and out of respect to the state's ability to resolve controversies as well, they're going to hold back on that. The dissent, the concurring opinion makes a couple of, I think, interesting points that are worth your consideration. What they're concerned about here is that whether his constitutional rights are in fact being chilled, whether there is this sufficient controversy. And Justice White actually talks about how this declaratory judgment could be accorded res judicata on any later prosecution. And that's always an open issue with respect to whether declaratory judgments can truly act as res judicata. They are, at the end of the day, a final judgment. The problem is that they're not always afforded res judicata effect. Res judicata means, as you know, that there's been a full, fair, and final judgment on the merits of the case. And that's a question of to what extent the declaratory judgment goes into the merits of the case. But if there is, then that judgment is preclusive as to all, not just the matters that were litigated there, but matters that could have been litigated. The problem is the declaratory judgment always leaves some matters open, certainly items of damage and things along those lines. Declaratory judgment is not going to fully resolve for us. And then the Rehnquist and the Chief talk simply a little more about the mutual respect that should exist between our federal courts and our state courts. We tend to think of federal courts as superior to state courts, but they are not. They are separate, and they are supposed to be considered as co-equals, although we tend to think that the federal courts are courts of appeal from state matters. They are not necessarily. And so the fact is that they do have to provide a level of respect for the other to be able to both act on controversies before them, and then once those decisions are granted, to provide them an appropriate level of res judicata or preclusive effect. You got questions on this one? This is really sort of a classic declaratory judgment case. The problem is, in the real world, we don't do a lot of free speech cases. They tend to focus on more contractual disputes and the like, although the free speech situation it's a pretty good example where you're going to have competing controversies and competing law with respect to the federal court's exercise of the constitutional law, as well as the state court's criminal prosecution as well. Mitchum versus Foster. Now this is another, at least in part, free speech case, but it talks about the Anti-Injunction Act, which is something you should be familiar with. Federal Anti-Injunction Act statute provides that a federal court may not grant an injunction to stay proceedings in a state court, except as expressly authorized by an act of Congress or where necessary in aid of its jurisdiction or to protect or effectuate its judgments. Again, you got to understand where the exception comes from, because what we're starting from is a basis of these are equal courts which should be providing some level of respect to the other and respect to the other's process to be able to resolve those disputes. The problem is there are times where either we ask the federal court to potentially enjoin pending state court actions, or we may ask, and again, when I say enjoin pending state court actions, what we are asking them to do is enjoin the parties from proceeding in those actions. We don't enjoin the court, we enjoin the party against whom the court has jurisdiction over from proceeding with that action. If the court, so either it's federal to state, or sometimes it's state to another state, where we're seeking to prohibit the party from either moving forward in another court on the same matter in a different jurisdiction, because it's duplicative, it's a waste of time. And so what we're asking is that those matters be stayed pending the resolution of one or the other. When we have the Federal Anti-Injunction Act, we have a specific statute that comes into play which says that you may not grant an injunction of state proceedings in a state court except as expressly authorized by act of Congress or where necessary in aid of its jurisdiction. And that's obviously a big thing, or to protect or effectuate its judgments. And so when you're thinking about why a federal court may want to get involved, if it's got jurisdiction over the controversy and the parties, the fact is that to allow these sort of collateral actions to be proceeding in state court are both time-consuming and expensive, and likely not likely to help resolve the matter, but only to throw more gasoline on the fire and create other controversies that at the end of the day have to be resolved. And so to some extent, a stay of proceedings somewhere while the main action proceeds is a good use of judicial resources, and it makes economic sense, because a lot of times we have multiple actions pending in various courts, state and federal, and the fact is that there has to be one action that is more likely to be able to resolve the bulk of the controversy than to have actions sort of splintered in a couple of different courts. We're running from Maryland to Boston and back and forth to state and federal court. And so you need to think about under what circumstances we could ask a court to stay a matter in another case, in another court. And obviously here it says one of the arguments would be necessary in aid of its jurisdiction. So in this case, the question before them is whether expressly authorized exception to the anti-injunction statute permits a federal court in a 1983 suit to grant an injunction to stay proceedings in a state court. Because in order to do so, then you're going to have to say that 1983 actions are special. And so this Mitchell versus Foster case is an interesting case. The prosecuting attorney of Florida brought up proceedings in Florida state court to close down the bookstore as a public nuisance under the claimed authority of Florida law. The state court entered a preliminary order prohibiting continued operation of the bookstore. The plaintiff feels that it is a violation of his First Amendment rights, and therefore his civil rights have been violated in 1983, and he wants to go to federal court to prohibit this constitutional, this impermissible denial of his constitutional rights. It says here now, for both this week and next week even more so, we're dealing with a lot of nuisance claims, interference with real property, personal property, and so you need to be able to define these concepts. It says here they wanted to close his bookstore down as a public nuisance. What's a public nuisance?
Isn't it just kind of, I mean, there's a private nuisance where you would have to have some claim on your land, adjoining your land. A public nuisance would have to, it bothers all the citizens, I believe, I forget.
That's the way it's defined? Public nuisance, would you say bothers all the citizens?
Well, I mean, everybody has a claim to it because it's in the public forum, or, you know what I mean? It's not just, it can't be on private property.
But what is? What is?
Nuisance.
What is a nuisance? You all had torts, right? You all going to take the bar exam at some point. What's a nuisance? This is a public nuisance.
What is it? It basically.
Basically?
It bothers the. I can't think of the name. Oh, that's the private nuisance, anyways.
The rest of you can help them. You don't have to sit here and make like you're invisible here. Huh?
This is good.
This is good. So, what's a public nuisance? Go ahead.
I would say something that interferes with the public's right to use public areas and facilities.
Something that interferes with the public's right to use public facilities? Is that what you said?
Well, not public facilities, because that's,
Okay, so say, give it to me again.
I don't know if I can.
Well, some, interferes, is that what you used? So any
I would say
interference?
interferes.
Huh?
I can stand by interferes.
Okay, you like interferes, George. Okay, so what is it?
Something that interferes.
Something that interferes
With the public's right to enjoy,
with the public's right to enjoy.
that's the part I'm having trouble with.
Well, any of the rest of you could help.
Public property?
Public
You have
property.
injury or loss in the.
Whoa, wait a minute. Let's, so is that, so is you go with that?
If
Any interference?
there's an injury or loss that they can make a substantial claim to that's on the merits, then they can, it's
Who can?
suffered by the common people of the area. Then they have a claim for public nuisance.
So give it to me again?
Any injury or
Because this
loss.
should be, by the way, right, we all agree, you should be able to define this concept, right?
Well, an
Because you
injury
must have
or
at some point.
Pick
Because that's the law, right? That's what you've been studying for a while. So, I mean, no, the law has,
I was gonna say big farm.
yeah, but, no, but
No,
this, okay, because this relates to the first part of our discussion tonight. I'm not looking for examples when I ask you to define what the law is, or a concept, right? You need to have it cold, right? If I asked you how to define hearsay, I'd expect you to have it cold, okay? Same type of thing with these other terms. In order for you to apply it, you need to be able to define it. And then you've got to define it well, not fuzzy, so that when you've got it, you've got it. So you got something?
Hopefully.
Okay.
Just an interference with a right that is shared by the general public. It's intentional.
Aaron says it's an interference shared by the right of the general public?
It's interference with a right that is shared by the general public.
What do you
An
think?
injury or loss shared by the public.
Something that threatens the welfare of the community, the health, the safety, or the moral.
So say what yours is?
Well, I think it is. Something that threatens the welfare of the community, either the health, the safety,
Something that threatens?
the health,
So like the Sanev is a public nuisance?
the what?
Sanev, the bombing at the marathon. Are they public nuisance?
It was a terrorist.
I know, but I think they would meet the definition you just gave me.
Well, I guess at a basic level, right?
Well, is it?
I don't know.
No, but you're supposed to know, aren't you?
I think you can make the argument.
Huh?
You can make the
You
argument.
could make the argument that they were a public nuisance.
They were gonna do it again.
So, because you used interference, she didn't use interference. Is interference part of a nuisance? And is it any interference, or does it have to be an unreasonable interference?
Yes.
It does, you want to add,
Unreasonable and substantial.
Okay, Aaron now wants to say it's an
We're
unreasonable,
extending this definition.
say what?
We're extending this definition.
Okay, it's an unreasonable and what was it?
Substantial.
And substantial interference with the right of the public to what?
Sure.
No, I thought you said something, with the right common to the public.
Sounds good.
Well, what about that? An unreasonable, and you want to say substantial,
Yes.
interference with a right common to the public. So my little note says, does that sound right to you?
About an unreasonable or unlawful use of property that causes damage, injury, or inconvenience or annoyance to another in the enjoyment of his reasonable rights. But it would have to be the public, would be the shared by the public.
So what you would do, a nuisance, and now you're going to, was that nuisance or public nuisance, what you just read?
No, that's public nuisance, an unreasonable interference with a right common to the general public.
Okay, that sounds like pretty much what Aaron had for us, right? Okay, who gets to sue for a public nuisance? Can a private individual sue for a public nuisance?
Is he suing on behalf of a group?
No, I wanted to, how about if I am affected as well by that public nuisance?
Just you?
Well, I'm the only one that's filing suit, but so can I sue for a public nuisance, even though it doesn't just affect me, but it affects me as well? Like you said, Mark was saying he was going to give us an example of the piggery. Well, if I'm living next door, I've got some damage as well. Can I sue to try and prevent that, both public and, as I would see, private nuisance? By the way, what's a private nuisance then?
It only affects you.
It only affects you, that's your definition? So, no, but what's the definition for private nuisance?
It interferes with your use and enjoyment of your private property.
Okay, so we've used the same words in unreasonable interference with your use and enjoyment of your property.
Correct.
Okay. We left off the substantial. You still want substantial, or could it be unreasonable interference enough, depending on whether it's public or private? It's just a question of whose interest is more affected. Could a dirty bookstore be a public nuisance? An unreasonable interference with the right common to the public. It could be. Why?
Brings a criminal element.
Brings a criminal element, or an unsavory element. Certainly I wouldn't want to live next door to it.
Could it bring a criminal element?
Potentially if it causes.
Well, it could be criminal, but it could also just be, people that you really don't want to hang out with, right? No?
I don't want to hang out with you.
No, but I mean, that may not be, does it have to be criminal?
No.
Right? So but it could be, and certainly,
How would you get around the whole free speech thing, though?
well, but that's obviously going to be part of the problem here. We had and this was a while back now, we had a huge problem in our town in North Andover because they thought they'd be real clever, and they zoned it for an area near the town dump. And so then someone said, okay, I'll put it near the dump. And then they said, no, you can't do it there either. And he said, okay, I'll do a recycling thing there at the dump. They said, no, you can't do that either. He said, oh, what the hell? The only two uses which that land is zoned for, and I'll take one or the other. And then he said, no, you're not going to get either. So obviously, suit ensued, and as you point out, their constitutional rights, they settled for the recycling station. The bookstore is out. But it costs the town a lot of money. But okay, so what about his rights at the end of the day? Listen, we've got, over the course of the next couple weeks, you're going to have trespass, you're going to have nuisance, you're going to have public nuisance, private nuisance. You need to be able to define the concepts, right? And, the fact is that you're heading towards the end now. You still need these concepts, even though they're first-year concepts, because you're going to be taking the bar exam. So it's worth it to start to get cold what the law actually is, so that you can recall it like that as you can start to see it, and start to think about being able to use it, because you've got the bar exam that's coming down as well. And there are some of these concepts, especially, by the way, with respect to nuisance, with respect to trespass to private or public property and the like, as opposed to declaratory judgments, which I've seen very rarely in my practice, from a standpoint of having represented individuals, a lot of companies, you see a lot of nuisance arguments, requests for injunctive relief about people wanting to stop other people from encroaching on their land or doing things next door. I think in part because this is usually people's single biggest asset, and if their use and enjoyment of their own property is somehow impacted, they're willing to litigate it extensively. And it always surprises me a little bit because you still got to live there. But these types of matters oftentimes are litigated to the end, because we get various encroachments, which would be trespass. We get various problems in neighborhoods and the like. And so I've had a lot of cases where we've got questions of nuisance and the like, or trespass, and oftentimes litigated, oftentimes coupled with requests for injunctive relief. But this is really more, again, another free speech case where they're looking for declaratory judgments and the like. I also have another portion of the nuisance at the bottom of my notes here, and this says it's an unreasonable interference with the health, safety, peace, comfort, or convenience of the community. So that's when we talk about the right common to the public. And I think you're right that one could make the argument that the bookstore could easily be within that state statute defined as a public nuisance. But you've got a bigger problem here, is there is in fact a pending state court matter. And while we know there's an Anti-Injunction Act as a general matter that says federal courts should keep their nose out of state court matters, allow the state to proceed on its case. If there are constitutional defenses, those constitutional defenses have to be heard. And at the end of the day, if the federal court has to come in and help clean it up when the state matter has run its course. And by that, as a general matter, what they mean is not just the trial court level, but the appellate court level as well. The fact is, comity, federalism, the mutual respect that the other is supposed to have means you are supposed to allow them to litigate the matter and resolve it and provide them the respect that you would want your courts to have. The problem here is the Anti-Injunction Act, there's some significant question whether since 1983 are civil rights actions. And by that, Congress has expressly decided that civil rights actions might be unique in nature and clearly deserving of different treatment that would normally not allow a federal court to stick its nose in pending state court matters. The Supreme Court has to decide whether 1983 is a special beast, that when someone comes into federal court with a 1983 action arguing that their civil rights have been violated, whether that might give the court the ability to enjoin the pending state court matter if it found that there was a sufficient basis for it. And as you work your way through the case, this court does carve out an exception for 1983 actions, being one of the rare examples where the federal court might use its extraordinary power to enjoin pending state court matters. By the way, it doesn't necessarily take this rare 1983 vehicle. It also said in order to effectuate its jurisdiction in the case or in aid of a judgment that it already rendered. So there will be occasions where the Anti-Injunction Act doesn't come into play. What's rare is in this case that a 1983 action, the court is saying if the 1983 action is pled in federal court, that does give the court the ability, where it normally would not do so, to potentially stick its nose in pending state court matters. And I think it's very rare and it's very unusual, but what the court does allow them potentially to do is to enjoin pending state court matters if there's a 1983 action pending in state court. And that's all the court is saying here, is that you're wrong if you say you have no power to do so. You have power. There's still a legitimate question whether it would be appropriate to exercise such extraordinary power, but in the right situation they may well do so. As Everett points out, if in fact he's simply selling books, isn't that, and hasn't that already been down that road many times, of likely a free speech issue? And how can you then, if in fact it's a free speech issue, deny him, even while that case proceeds and winds its way through the state court system, the ability to exercise his First Amendment rights? What they're saying is that may be a situation where 1983 says that you can't do that under those circumstances. And therefore, this may be an appropriate situation where the court can exercise its extraordinary power to potentially enjoin that prosecution in state court if it found that it wasn't based in good faith, or that the state court might not entertain his constitutional defenses, which they would obviously have to. The end of this, the concurring opinion, simply cautions whether the court should exercise that type of power in order to enjoin that pending state court matter. At the end of the day, while the court has the authority to do so, what they're cautioning the courts before that you were wrong to say you had no power, even if, though, you, in 1983, provides you the power, which it does, you should not do it lightly, and it should be a rare circumstance where you're going to do so unless it's either in aid of your existing jurisdiction or to effectuate a prior judgment of your court. The Anti-Injunction Act still is a cautionary note about federal courts involving themselves in pending state court matters. Question on that one? The last one you've got to do, and I'm going to save it for the next time we meet, is this Francis case. And I thought Francis was an interesting case for you to look at as well, because it lays out the findings of fact and conclusions of law in a pretty straightforward fashion, so you can actually see what they would look like when the court issues a decision in that fashion, as opposed to sort of the essay decisions that you oftentimes look at. So look at Francis kind of carefully. It's more here for the findings of fact and conclusions of law, although it also is an interesting declaratory judgment case with other multiple counts, as we talked about at the outset, where the court is able to use the declaratory judgment as well as these other legal arguments to be able to bring the matter to a conclusion. So,
What's the name of that case?
Francis, Frantzis versus Horowitz, Horowitz. The Westlaw site is WL22872667. It's a 2003 Westlaw case. Take a look it over. We'll talk about it on Thursday.